All rise. 14A District Court for County of Washington. Back in session, Councilman Judge Jason.
You may be seated.
Never mind. I'll be right back. Thank you.
So we answered it. Okay. Court calls the case Arbor Woods versus Sarah Gore.
Good afternoon, Your Honor. Rachel Dornbush, Pallets Law, P78301 on behalf of the plaintiff.
Ms. Gore, you are present.
Yes.
All right, and this is a non-payment of rent. How much is owing?
Your Honor, there is rent to retain of $4,808.27. Costs are $188 for a total due of $4,996.27. Your Honor, Ms. Gore and I did reach terms for a proposed consent judgment, and the agreement is that Ms. Gore is going to pay that amount plus August and September rental charges as follows. It will be $1,000 on or before July 31st, the August rental charges on or before August 14th, $1,600 on or before August 31st, September rental charges on or before September 11th, and then the remaining balance on or before September 30th. Your Honor, I did discuss with Ms. Gore that if there was a default on the agreement, that plaintiff could file for an order of eviction without further hearing. And I did advise Ms. Gore of her rights under MCR 4.201J. She did give me permission to sign the judgment on her behalf, and I let her know I would CC her when I submitted the judgment to the court.
All right. Ms. Gore, is all of that correct?
Yes.
Do you have any questions regarding the judgment or its terms?
No.
All right. I will grant the judgment and I will sign it upon presentation to the court by consent.
Okay, thank you.
Thank you, Your Honor.
Thank Arbor Woods versus Marcus Hollis. He's a dialer.
Hello?
Hello, your name? You need to unmute. Hit *6 on your phone.
Marcus Hollis.
Thank you. All right, what is plaintiff's claim? Well, there was a judgment.
That's correct, Your Honor. There was a judgment and I believe an order of eviction was processed and I believe it was issued by Your Honor on July 2nd. It may have already been posted and served on Mr. Hollis. I believe that is the case because there was an agreement reached between Mr. Hollis and my client for Mr. Hollis to make some payments on July 14th, on the 16th, and then to have the balance paid in full on or before July 31st. But Mr. Hollis didn't make those initial payments that were agreed upon from what my client has advised me. And I spoke with Mr. Hollis yesterday, and I don't know that Mr. Hollis is confident that he's going to be able to have it paid down to zero by the 31st. The judgment, Your Honor, was for $3,608.45. That judgment entered back in May. Currently, the balance is $5,442.78. And so, Your Honor, my client's still willing to go to the 31st. They're just not willing to go beyond that.
Got it. Mr. Hollis, what do you want to tell me?
Yes, sir. I'm just fighting a child support case, and it's cutting more than half of my money in every week, and I'm just fighting that. And I should be getting more of my money so I can make six-figure payments. And this is all I'm going through right now. Yeah, I heard. Yeah, if I'm trying to get it down to at least where I can use my credit card and pay it. So that's why I've been
Okay.
trying to put it in escrow or whatever and take it down to at least the amount that I can charge it and get it to zero before the 31st. But like I said, I'm going through child support court, and that's
Okay.
a whole nother.
To get into your credit card business, but how much are you able to put on your credit card?
2,500.
Huh?
Mhm.
So,
Your Honor, there's 980 that was
80,
paid in
right.
escrow. And I guess, Your Honor, the issue that I have with that is that it's supposed to be 1 month's rent. 1 month's rent's actually $15.99. And so 1 month's rent hasn't been paid in escrow.
Yeah, this is a non-payment case, and I think I had to teach my clerks to look at things differently. Because you clearly had the rental rate of $15.99 on the complaint. Okay. Yeah, I don't see, and I was just going through with the 9 and trying to see how the math was going to work, but it doesn't even work for the judgment, quite frankly. With the 20, it just doesn't quite make it. So, sir, I'm going to deny your motion to stay the writ and set it aside. All right?
All right. So I can still pay the 5,000, or don't pay the
Well, you at
5,000.
least have to get the 3608, but then they're going to be right back at you. And the only reason they're
Next
granting the
month.
additional time is so that you can get everything caught up.
Your Honor, my client's
So
position
30.
is that he's got to pay the 54 because the time frame to pay the judgment was back in May. This is
No,
now.
I hear you. I'm just saying it's going to be where it's going to be applied. I mean, let's put it this way. The agreement that was made was really to pay the full balance ultimately. And I'm saying I'm denying the motion, letting it come across, whatever the effect might be, is to be judgmental.
So I could pay the 36. Is what you're saying?
Well, that their
Because that's
position
the
is
initial agreement.
you've got to continue on the agreement, whatever the agreement was.
So the initial agreement was under 36, not 54.
Well, frankly, then, Your Honor, my client wants to proceed with the writ Monday. I mean, they're giving him an
But I'm
opportunity to
just
bring his
saying, like,
account current. I understand where Mr.
that,
Hollis
I'm
is
just
coming
asking a
from.
question. I'm just asking a question.
The original agreement, Your Honor, the
Their
judgment.
position. Go ahead.
I'm sorry, Your Honor. I was certainly not trying to interrupt, Your Honor.
No.
The original agreement, Your Honor, was entered back in May 15th, I think was the court hearing. And the agreement was he was going to pay $600 on or before May 18th, $600 on or before May 29th, $600 on or before June 5th, and the remaining balance with June rent on or before June 12th. Of that agreement, Your Honor, Mr. Hollis paid $600 on May 26th. He paid $500, $600 on June 3rd, and he paid $600 on June 18th. And at that point, left a balance due and owing more than what the original judgment was for. It was $3644.86 at that point.
And
Yeah.
and then I also got a emergency. I talked to what's the name? SER. I got an SER in too.
Well, that's not going to help right now. I mean, it may
I know
help
it's
in terms
not,
of
but
paying something off.
Yeah, and that's what I don't know. I haven't got my email or anything, or they said it was gonna get mailed to me.
All right, sir, what you're going to have to do is you're going to have to get that balance paid off.
All right. So
Okay,
how,
thank,
can I pay half so if I put it in escrow, if I go pay half in escrow, am I able to charge, no, I'm just asking you a question. If I put the money in
I
escrow, is that
understand.
gonna change the balance on the site so I can charge it?
I don't know how to answer that, sir. I'm just telling you, whatever you work out with your landlord is fine with me. I'm just indicating that I'm not setting aside the judgment or staying the writ in this case. The escrow will be released to plaintiff. Thank you.
I don't answer nothing.
Serious. Court does call the case of Arbor Woods versus Sonia Chappell. Oh. Hello.
And Your Honor, my understanding is that Ms. Chappell paid today. I think there was a very small balance due. My client said that she was planning on addressing that this afternoon. I don't know if Ms. Chappell did drop off that additional small payment. I'll defer to Ms. Chappell regarding that.
No, I didn't.
Okay.
It, like she said, it is a small balance.
How much is it?
It was
Like $39, Your Honor. I'm not inclined to take a judgment for $39.
it's $39.44, but they added that on to the total. My total that you told me, I owe $966. 40.
I had the Joe 968 and what a late fee kicked in.
Yes, that's correct, Your Honor. So you may recall at the last court date, Ms. Chappell had appeared and she had a concern regarding a forced mo charge. My client credited that. It brought the balance down to $911, but a late fee hit. And so when Ms. Chappell paid the $911, it left the balance due, which is comprising of the late fee. And so I'm not inclined to take a judgment for that, Your Honor. I would dismiss the case and just say that if Ms. Chappell wants to pay that with her August charges, that's fine.
What is the charge for?
It's a late fee.
Oh, okay. I have no problem with charging that, but I just wanted to address, this was on my door Saturday after I left here Friday to leave, to evict me, and it's from June. I just wanted to address.
Oh, no, okay, so here's what happened, man. They filed for the writ for the order of eviction. It must be from a June case?
Oh, you know what, Your
I
Honor?
I paid it first.
Go ahead.
Yes, Your Honor. And looking back, it looks like there was a case that was filed back in May.
June.
There was a case filed in May, a judgment entered by default. There was a case filed in May, a judgment entered by default. Looks like on June 16th. And I'm not sure how there was a second case filed, but the writ was signed by Your Honor on the 16th. They're not going to act on that writ, and we would dismiss this.
They're not. Okay. That's okay.
I just wonder why it was on my door when it was.
Because that's how writ would normally be processed. If you never gotten to that stage, that when I sign off on the order of eviction, that's what happens.
So come to court, don't pay it.
Come to court. What do you mean?
Because I guess this is the notice to come to court, right?
No, that's the notice to evict you. That one that you got in your hand?
Because I didn't come to court.
Because of the last case.
Yes,
Right,
and Your Honor, if Ms. Chappell wants to give me a call, I'm happy to kind of go through the timeline with her. In any event, she's not facing eviction based off of that order.
You don't have to worry about it.
That's all I wanted. What's your name and number, ma'am?
Ms. Chappell, if you look at that paperwork that order of eviction, it says plaintiff's attorney Matthew Pallets, and there's a 248 number out of Troy.
Phone number, I think it is.
Oh, okay.
See that?
Okay.
It's for Rachel Dorn. All right.
That's all.
Don't worry about that. I'm gonna dismiss the case. All right.
I know it's been that morning for y'all.
No,
Counselor, they charged me another $55 for lawn.
When
And
was that done?
oh, that's a
Forest Lawn, July 1st and July 20th, and neither one of them did they cut
No, no,
my
that's a
lawn.
credit, ma'am. The one on July 20th is a credit to your account. If
That's
you know
okay, but
it-
she just credited me that one. But again, the July 1st.
that,
but
so the
the
July
credit-
1st is the charge, the 20th is the crediting that charge, reversing it.
So it's not two charges.
it's not two charges.
Sorry. Thank
Are
you.
you gonna be able to make it all the way to the door without turning around and yelling at me saying you gotta say something? No, I'm just asking, because otherwise
Bless y'all.
I'll wait.
God bless y'all. Y'all have a safe, wonderful week.
You do the same. One thing. No. Yes, I have. Arbor Woods versus Sharisha Roberson. Hello.
Good afternoon,
Afternoon. What's your name?
Sharisha Roberson.
All right. And Dornbush, what do you have as the balance?
1839.79.
Well, I saw assistant from the Housing Bureau for Seniors, and Melanie is assisting me to.
Yeah, she's there. She's giving me problems every time she shows. She just gets up here and tells me what I'm going to. All right. Where are we with her case? State your name, please.
Hi, Your Honor. Madden Linton, Housing Bureau for Seniors. This is similar. We filed the 14 days last Friday, or within 5 days of the first hearing, but we didn't get the 14 days. So I'm just here to say, can you?
No, she got the 14. She got her time.
Because she was here just last Friday. And then we
Her
all.
first hearing occurred on July 10th,
Okay.
hearing July 17th.
Okay.
Now we're here on the 24th.
Okay. So that's what
I know you were yelling at me about that on the last case.
Okay. Well,
It's rare that somebody does not get their 14 days.
that's why I was like, something's wrong.
And quite frankly, with or without the paper.
Yeah.
Quite
Yeah. Yeah.
So
Okay, well, we're just coordinating with M Healthy, which is another U of M agency. So they're just processing. So, I mean, it would.
they're gonna be able to get this paid then for her? So
Yeah. Yeah.
Okay.
I should be able to pay August. It's gonna be not on the 1st, but on the 5th of August is when my payroll will.
Payroll
Yes.
comes in.
Because it comes in on Friday, but because of the bank, they do a courtesy 2 days. So the last day that I can pay without being.
Without a late fee.
Yes.
All right. Here's what I'll do. I mean, you guys have never not come through without or a check, so I'll trust you.
Oh, wait.
So I'm going to adjourn this to August 14th, 2026 at 12 noon. Okay. Hopefully we can get that paid. You will have by the 5th.
August.
Yeah, by the 5th of August, paid August.
Yes.
And then you won't need to come back and see me.
Okay. Thank
I mean, you can. Don't bring her with you.
you.
No, I'm kidding.
Package.
But no, you won't have to come in if everything's paid. Don't.
Okay. Okay. Thank you. Thank you.
All right.
Just.
You're welcome.
Bye.
Great weekend. Northville Crossing versus Ardell Carson.
Hey, Judge.
Hello. How are you?
I'm fine. How are you doing, sir?
I'm not too bad. Not too bad. Okay. Ms. Dornbush, where is Carson? Miss Carson in this.
$1,098.34.
All right. Ms. Carson, how are you going to get this paid?
I'm still working with Autumn from SOS Community Services. She just sent me another email I guess she needed an updated benefit letter from my father. I already turned in mine to show our income. So that's what I'm working on now. I guess that's all she needed to
And
receive
then,
the commitment letter.
and then they're gonna pay it. Is
Yes,
what
sir.
she's telling.
Yes, sir.
All right, so let me ask you this. If they're paying through July, how are you gonna take care of August?
August we'll be able to take care of with our regular monthly rent.
Got it.
We just
Okay.
need help. Yes, sir.
Okay, so here's what I'm gonna do. All right, rather than adjourn it out, I'm gonna find no tribal issue after hearing. And I'm gonna grant a judgment for possession to the plaintiff, and I'll explain why I'm doing this, Ms. Carson.
Okay.
For the total amount of the 1,090.34. Okay,
Okay.
so I'm gonna grant that judgment for that amount,
Okay.
but going to extend the.
Okay.
Okay, so let the folks know let Autumn know that they have until the 7th to get it cleared
Taken
up.
care of. Okay.
Okay,
Okay.
and then
Awesome.
yeah, we'll do it that way. Okay,
Yes, sir. Thank you so much.
thank you. You have a great weekend.
All right, you too. Thanks a lot. Appreciate it.
Ohio Farms versus Melanie Clements.
Your Honor, Ms. Clements did make a payment in full, but we need to verify that it is cleared. So if we
Got
could
it.
adjourn this, that would be great.
August 14th, 2026, 12 noon, right? And Ohio Farms versus Bridget Long.
Your Honor, Ms. Long is not present, but you may have some email correspondence from myself with Ms. Long CC'd on it, indicating the reason for her non-appearance today. We did reach terms, though, for a proposed consent judgment, which was submitted along with a signed advice of rights, indicating a total redemptive amount of $2,482.55 to be paid on or before August 3rd.
Yeah, I see that. And she was apprised of everything under it. Yeah, I see that. I will enter that consent judgment
Thank you, Your Honor.
in that amount, 2482.55. That's that. Okay, fantastic. I think I only have one more. And that is Sylvan Crossing versus Wolf. That's a dismissal.
It is.
All right,
indeed.
that's it. You guys have a wonderful weekend. Hello, Patty.
Hello, how are you?
I'm doing well. And how are you doing?
I need a vacation from my vacation.